Good morning, everybody. How are you today?
We're fine, thank you.
My name is Yulia Sergeyevna, and we'll start today our fantastic course of adjudicating disputes. First, before we start our work, we should establish with you some rules of our cooperation in order we have great results and our work will be very fruitful. First of all, we need to be polite, we need to be active, so you can put questions for me, do not hesitate to do it. If you don't understand something, you may clarify it and I will answer to your questions with a great pleasure. And the third rule, you should make notes in order to prepare for practical classes in future and have information in written. So, on this optimistic point, we'll start our lection. And our first lection has the topic of the arbitration as a way of alternative dispute resolution, ADR. Outlining the main issues of our lection, I need to mention definition of arbitration, disputes which cannot be subject to arbitration, types of arbitral tribunals, arbitration clause and arbitration agreement, and procedural options. When we are talking about alternative dispute resolution, as you see ADR, I will use this term for the next period of time, we mean the way of resolving disputes without official judging system. It means that we do not go to the official court, and resolve our dispute. We just have the resolution between two parties, disputable parties, and the third independent party, arbitrator, one or two or three, the quantity depends on you. As you can understand, the dispute which falls in the jurisdiction of general or economic court can be arbitrated. But what arbitration is? And the answer is too simple. Arbitration is the process of adjudicating disputes with third or dependent party arbitrators who are not official judges. It's not an official system of resolving dispute, but it works in reality. As you know, you have some knowledge of constitutional law. The arbitral tribunal is entitled to adjudicate the case and deliver final decision. But the question arises here. If these actions of arbitral tribunal do not violate the provision 1 of Article 124 of Constitution of Ukraine, where it is provided that justice is carried out exclusively by official courts in Ukraine, and no one and nobody can do this. And the answer for this question is the decision of Constitutional Court of Ukraine. And the proceeding of Constitutional Court began in order the motion of 51 national deputies of Ukraine, and the Constitutional Court established that judicial decision adopted by the official courts on behalf of Ukraine and are valid on the entire territory of Ukraine. Instead, the decision of arbitral tribunal is carried on behalf of this tribunal, but not in Ukraine, and is valid or legal or binding just for the parties of the dispute. It's the main difference. What is more, the enforcement of tribunal's decision is not included in the sphere of arbitration, and is the function of competent courts and bodies of bailiff service. So, the Constitutional Court concludes that the operation of arbitral tribunals does not violate the provision of our Constitution, are legal, as the arbitral tribunals, as I said before, does not carry out justice, tribunals' decisions are non-state acts, and they are a result of the parties' disputes resolution. So, does it make sense for you?
Yeah.
Thank you.